does the office of Florida governor have an executive privilege which gives the governor the power to withhold public records? Florida has a strong set of so-called sunshine laws that make most government records and documents accessible to the public unless they are specifically exempted. This week in Tallahassee, an attorney for the governor argued that the governor does have the right to use executive privilege to keep documents secret whose disclosure would threaten the confidentiality that is necessary to perform an enumerated constitutional duty. It's a case involving a public information request for the names of the people who discussed with the governor whom to appoint to the Florida Supreme Court. That request is based on an August 2022 interview in which DeSantis told conservative commentator Hugh Hewitt that a group of 6 or 7 pretty big legal conservative heavyweights helped him screen candidates for the Florida Supreme Court. A lower court has already sided with the governor, saying he does have an executive privilege allowing him to keep the name secret. But that decision is being appealed. The attorney representing the person who made the public records request said that the Sunshine Law amendment passed by Florida voters in 1992 does not include an exemption for the governor's records, and that no other chief executive in the state's history has invoked such an exemption. If DeSantis wins in the courts, it would give him and future governors power to potentially allow him to conceal a broad range of government records from the public eye. Gerald, does the governor, under current Florida Constitution, have an executive privilege to withhold these kind of records?
No and no. It just doesn't exist. It's trying to be created in the minds of judicial officials. There was a lower court judge who issued the ruling saying that executive privilege applied and the governor didn't have to turn over this information. That's been appealed to a higher court, District Court of Appeals, because they believe that there is no such thing as executive privilege. What DeSantis has done is to join forces with 2 of the least reliable figures in American politics, Richard Nixon and Donald Trump. Richard Nixon used executive privilege during the Watergate years to justify not turning over the tapes. And that was the big question before the United States Supreme Court. And Donald Trump, of course, has used executive privilege for everything, saying he doesn't have to turn over everything. Florida has long had this process of open things to the public, let the people know. That's a good policy. Florida was a state since 1845. There's never been any executive privilege as part of turning over public documents. So it just doesn't exist, and judges shouldn't create it. They have no right to do so. The public in 1992 voted to have open records in the state of Florida.
April, you're holding your breath. I think you want to say something. What would you say about this?
Trump derangement syndrome has hit Tampa today. This is about the governor, and you know, for years and years and years, probably from the beginning of time, governors have consulted with people that they trust, because they can't possibly know everybody in the state of Florida to make these types of decisions for appointments. And it's appointments across the board for every board, council, directorship, and the courts as well. But that's historically has always happened on both sides of the aisle, is that governors seek input from those who know their candidates. Should it be secret or not? That depends, I think, on how it's done. There's a lot of questions in this case about how the request was made, the fact that the person who had made the request and has filed the lawsuit has remained anonymous as well. Should that be secret?
Yeah.
Okay, we're talking about secrets. If he wants things to be out in the public, let's hear who he is, okay? Or she, whichever the case may be.